Good day, everybody. I'm Richard Fink, a lawyer who specializes in workers' compensation law. Today is the Injured Workers Side podcast for workers' comp. I'd like to introduce my co-panelist, Paul. Paul?
Hi, my name is Paul Taylor. I'm a licensed paralegal with a specialization in workers' compensation and human rights law, which is going to be interesting because today's podcast is about return to work. And I won't shut up about human rights. If you want to reach out to either one of us, Richard or myself, and be part of our podcast, you can contact us through the links below. Like I said, this week's topic is regarding return to work. And as Richard mentioned, his assistant, his very brilliant assistant, Pamela, is here to talk about it with us. Go ahead,
Thank you.
Pamela.
Thank you very much, guys. So I've been working with Richard. I'm on my 21st year. Just to give a bit of background, I am the senior law clerk at Fink and Bornstein. And as Paul and Richard were talking about, we are going to talk about return to work, more specifically, suitable occupations with work transition services. So recently, I wrote out to the WSIB, specifically February, outlining that one major concern that our office has been having for several years is that the WSIB does not provide the detailed research that they use in order to come up with a suitable occupation and a work transition plan. Basically, what happens is once an injured worker is unable to return back to work with an accident employer, they are then turned over to the WSIB for return to work services through retraining. And just to give a bit of background information, the WSIB, when they look at work transition services, also known as retraining, there is four criteria that the WSIB looks at in terms of determining whether or not an occupation is suitable and a person can be retrained in that occupation. The first criteria is functional ability. So that just means, can this person functionally do the job? Are they able to meet the limitations of the job duties for the occupation?
Pamela,
Yep.
sorry, I don't mean to interrupt you, but
No, it's okay.
when we get into that subject, that's a huge subject for me for two reasons. One is who sets the functional abilities? And two, is it specifically just physical or is there also what we call as mental limitations as well?
So the WSIB determines the accepted restrictions, physical and psychological. So what happens is the case manager will pull the medical information. They will render a decision letter saying, under this claim, these are the physical and psychological restrictions that are being allowed. And then that information gets flipped over to a return to work specialist. So in many cases, there are situations where an injured worker doesn't agree with the limitations because they say, well, you've accepted these physical and or psychological limitations, but I also have other issues that I'm dealing under appeal or that I feel the WSIB is not allowing. So in those cases, what happens is the injured worker has to go by what the WSIB has accepted at that time. And then should you win an appeal and or get a new case manager decision, let's say updating those restrictions, then the new additional restrictions are supposed to be referred over to the return to work specialist.
So when the board is looking and saying, okay, Richard, I'm gonna determine your functional abilities, do they actually consult with the injured worker first? Do they say, okay, this is what we have from your doctor, and this is what? No.
No, no,
Hmm.
it's all done, but what happens is this is already taken care of before a case manager refers the file over to a return to work specialist. So it's the case manager's job when they're doing the referral to the return to work specialist to say, here's what I've reviewed in the file, here's what's been allowed. Some of it is temporary, some of it is permanent, some of it is neither temporary or permanent. It just lists what the restrictions are because the person could still be in some treatment. So it could be that they're going to get better down the road. This is one of my issues that I have because you're putting the cart before the horse. If people are dealing with an appeal or they're saying, no, I don't agree with this, or I'm in medical treatment and my situation could get better, or I'm going to have a surgery, whatever the case is, they're still trying to kind of push the injured worker through the return to work process and the retraining process, which to me doesn't make logical sense because you could spend all of this money, i.e. the WSIB, and then at the end of it find, oh, well, in fact, the restrictions have changed and now the person can't do that. And now you have paid all of this money for their retraining plan. But this is how the WSIB goes about it. As soon as they get to a point where they say, we have these restrictions and the person can return back to work, that's when the referral is normally done. And the accident employer can't take the person back based on what those restrictions are.
It's frustrating because I'm actually reading a human rights tribunal decision back when things were a bit better. I'll just use the word better at the HRTO. And what it was it was an injured worker who went through a retraining program. Back then they called it labor market reentry. And during the LMR assessment process and everything, the board didn't consult with the injured worker and saying, do you have any other disabilities? Now, to be clear on the term when we're talking about return to work and human rights code and everything, it is very clear in the code under section 47, the board must follow the code, and the code is primary over all other laws in Ontario unless the law says otherwise. Specifically, in the case of workers' comp WSIB, age is not included, which is problematic in many ways. Regardless, disability is covered. So when an injured worker has a disability, the board must accommodate it. Now, here's the thing that I've identified as problematic with the board and even the tribunal is when you're dealing with the board or tribunal, they see it, if they have to accommodate, as a work injury when it isn't. So they're saying in their mind, and I've been told this, well, I'm not going to pay you benefits for your disability. That's not it. What it is when when you first get injured, you then have to prove your injuries related to work, which is medical and everything fine. But when you say, I have this disability, whether work related or not, it's irrelevant, right? Because under the law, disability is anything under the various categories, physical, mental, vision, anything. Also, interestingly enough, in Ontario, the only one in Canada, it actually says that if a worker's claimed benefits under the Workplace Safety Insurance Act, that is a disability, whether it's accepted or not by the board. So, for example, if you have an injured worker with, say, a back injury and a neck injury, for example, the board accepts the back injury but not the neck injury. The board, in providing return to work services and retraining services, must accommodate that neck injury. So if it's like, well, I can't turn this way, so I can't do that kind of job, but I can do this job, you see? So they're immediately jumping to the worst case scenario and saying, well, we have to pay benefits, so we're not going to do that, which is a really flawed problem with their internal policies, right?
Mm-hmm.
And in Frankson, it was an interesting case because the guy had a learning disability. They didn't consult with him, which the law mandates they must, and say, what other issues do you have? And they didn't. He went into retraining. He was having difficulties, but he was managing. And for some reason, the board canceled the retraining program, which he wanted to do. So then he brought a claim with the Human Rights Tribunal. And what was interesting was the Human Rights Tribunal ordered the WSIB to change the retraining policies to make clear that they must accommodate persons with disabilities. So here we
Even though if they only have to accommodate the pre-existing disability.
No, no. A disability under the code is any disability. So, for example, it's as we say, work-related, not, it doesn't matter. It doesn't matter. A disability under the code is a disability. That's
Because
it.
the board's position is we're not paying money for disabilities that aren't pre-existing
Right. And that's their flaw
or
in their
or
argument.
post-act or they're
Yeah.
from the accident.
Yeah.
Because they're making a leap to saying, well, if I accommodate you, then I have to pay. No, not necessarily. In many cases, had they accommodated the person, they wouldn't have to pay anything. In many cases with retraining, well, if we say, okay, you have a neck injury, you can't turn, so we'll get you a job that does this or this or this, right? And this is where it's getting more complicated and more confrontational with the board and the tribunal with these return to work decisions because they're not properly looking at that situation. They're zeroing in and just going right to the money. And as
That's that's side issue, I think, to suitable occupation. So let's go back to Pam for a minute on suitable occupation. So Pam,
Okay, so the second criteria that we're going to talk about for the WSIB's criteria for work transition services is job availability, which means are there jobs available in the area that you reside in, and into the future, are there job prospects? This is one of the major issues that we see in our office because the WSIB does not properly look at job postings in a person's area to see if the job duties that are outlined in the job postings match with the other research the WSIB does. So the WSIB looks at the Ontario Job Bank or Canada Job Bank, as well as looking at the NOC classification codes, which you can find online. Those two sites provide information that's more general, such as what is the job, what type of careers can you do from this job title, and what is the starting, middle, and experienced wage. It does show job prospects, but again, more details are needed when you're actually looking at job postings because you will see a difference between general information and actual job postings, especially in direct entry jobs.
yeah, when I went through that myself, and when I look at clients, and even looking at the policy, it's intentionally vague, the policy, in that they'll just say, well, we think you can be making this money and we think you can be doing this job. And it's very deceptive because I don't know if you've gone through the education process like Richard did, and he went to university and law school. But I did both college and university, and it's night and day difference. Like, I hate to say it, but it's true in Ontario and Canada is the higher the education area, like if you have university, you have a better chance of gaining employment, let alone good employment. You know what I mean? Converse with college or high school. But the board, they just look at a job and say, well, you can do this in college, so therefore you should be able to get employment. And if you can't, well, that's your problem. And they're not looking at that, that difference. And I've noticed many that experience with it.
The other issue that I always point out to people is that they'll look at a job that says, so a cashier. What is the job? You're working as a cashier. It's pretty standard, it's a general information. However, when you're applying for that job, let's say you're going to Walmart as an example, and you're applying for a cashier job. That cashier job, they also, if you're capable of it, they expect you to also do things around the floor. So they expect you to, oh, can you go and stock some clothes? Can you go and move some stuff around? So my frustration is that if you're looking at a generalized job description and then you actually compare it to a job posting, you will see that there are a lot of different job duties in the actual job posting that is not provided in the general information, which is why I started writing to the WSIB in February to say, why are you not providing more of this research? What exactly is the return to work specialist considering and looking at? Can you show us the actual data that's being used in order to determine whether or not this job is suitable? Because what you're essentially doing is the WSIB is writing to an injured worker and saying, we did all this research, we're not releasing it to you, and now you have 30 days if you want to appeal it. And the majority of people that we talk to say, well, I didn't know if I should appeal because I thought it would stop my benefits. It sounded like a good idea. I was trusting the WSIB. They said they did the research. So it's not only bad that you're not releasing the research to give to people, but you're also giving them 30 days to decide whether or not they can appeal. So anybody watching this that's in this situation, you know somebody that's in this situation, if there is a decision, whether it's regarding retraining or anything else, and there is a time limit, you need to file an appeal by way of an intent to object form. If you are in a work transition plan, you only have 30 days. Sometimes it takes 7 to 10 days to get the mail. You need to file an intent to object form and say that you are appealing for time limit purposes. That way, you meet your time limitation, you still fully cooperate and try your best, and if something happens, you can then proceed with your appeal. A lot of people don't understand this, and then they'll come to us and say, oh, well, I was worried about appealing. The WSIB told me, like, you have to fully cooperate. I thought my benefits were going to be affected. So this is a major thing that we see all the time. And this is why I started writing to the WSIB about it. I'm waiting currently for the WSIB to get back to me to answer some of my questions, which essentially was, why is the time limit only 30 days? You should give another decision at the end of the decision, or sorry, at the end of the retraining plan to say, do you want to appeal this now? Like, I don't know how they think that people are going to be able to determine at the beginning whether or not they're going to be successful in something. I mean, a lot of our injured workers are older generation. They haven't been in school for some time, and then they're not sure whether or not they're going to be successful. They don't know what it looks like.
That brings up again the age factor, which many people don't realize is actually discrimination based on their age. Like Richard's been able to adapt to modern technology because it's part of his job. But in many jobs and many parts of life, older people don't have to adapt to computers. There's actually people I know, older people don't have a cell phone. They have a landline at home and that's it. They don't have a computer or anything. They can't do Zoom meetings, videos, or anything else like this, or they can't file online on the computer like the WSIB demands now, and that's not accommodating them. But getting back to the workplace, it's interesting to note, and I'm reading from the Human Rights Commission's guide, and they actually quoted the Supreme Court of Canada that when you're doing the accommodations or the functional abilities or the work saying this is the work you can do, one key factor in that's always missed by the board is that it says that in setting the formula for accommodating people identified by the code grants, each person's needs are unique and must be considered afresh when an accommodation request is made. People sharing the same conditions often experience it very differently in different ways. So, like if you say, well, you have a back injury, you can do this job, right? Then the other factors, which is really important in dealing with the suitable occupation, I've read in many tribunal decisions, and I'll caution people that the tribunal can be conflicting, right? Contradictory would be a better word, where one tribunal decision will say this, and you quote that decision in making your arguments, and the vice chair, for whatever reason, just disagrees. And it's like, what? But there's further avenues that you can take. But at any rate, in that, they said that the board has to show clearly the working task that the person is going to do. Sitting there and saying, well, they're going to be a parking garage attendant or a cashier or general occupations. Well, okay, great. What are the specific tasks that this person with a disability are going to be doing so we know that they can be properly accommodated? You don't know? Then you're not accommodating them. And
Yeah.
there's decisions in the guide that go all the way to the Supreme Court. And what's interesting, I noted in this too, is that there's a section about systemic discrimination or institutional. And I think that's what we're experiencing. What I was talking about earlier was a human rights case that really shocked me because the Human Rights Tribunal had ordered the board to change the way they do retraining programs. And that was in 2011. Here we are, 2026, and they're doing the exact same thing again, which tells me that they haven't changed. Moreover, between that time and today, there's been other decisions, where the board is refusing to do anything. And you hear this, well, we're not going to pay benefits thing argument. Okay, that might be a valid argument in the idea of insurance and everything. It's not legal, but it's valid. But how can you make that a valid argument if, but for your failure to accommodate, this person wouldn't need any benefits? That's the actual legal argument. Meaning, if you, Pam, had a disability, say you couldn't sit for 4 hours, and they retrain you as a receptionist. It's like, wait a minute, what? But had they found you a job where you can sit, stand, walk around, do whatever, then you're fine. You see, so then because of the board's failure, now they have to pay you benefits or damages, right? And this is this disconnect that they're having. They're immediately jumping and saying, you're asking for benefits when you're not. You're asking for suitable accommodations.
Let
In the
me
work,
talk for a moment about paralegal as a suitable occupation because it's the case I was supposed to do yesterday at the appeals tribunal. And Paul can be an expert on paralegal as a suitable occupation, given you are one. So the client hadn't worked for 12 years. The case has been going on in our office for nearly 14 years, which is pretty stunning that we go on for decades on this case. The hearing was supposed to be yesterday, and my client got arrested. So that was the end of yesterday's hearing. The WSIB picked paralegal, even though the worker didn't want to be a paralegal particularly. They picked the job of paralegal, even though it's not mentioned in the vocational rehabilitation report of the WSIB. The worker passed his paralegal course. He had to do 133 hours of work, which essentially
Oh,
is like
internship, yeah.
4 weeks
Hmm.
of work. And then he's been looking for work for the last 2 years and found nothing. The problem is, and asked Pam, is is that did they have criteria as to who will get paralegal jobs or who won't in this file?
No. No. And I mean, they don't think about other things as well. Like they don't care to factor in like how many paralegals there are out there. The fact that the worker's resume is going to show that he hasn't worked for that period of time before, which is a big thing. Like if you go to apply for a job and it's like, hey, what have you been doing this whole time? It questions it. So there's a lot of things that were missing from the file, but no, there was absolutely no job postings or anything like that. He did the psychovocational assessment. The psychovocational assessment came back saying he would be a candidate for up to a 2-year college program. And then after further discussion with the WSIB, that's what they came up with.
What, if you don't mind me asking, what was his education and his background prior to this assessment?
So the thing was that he was like, I think he was a general laborer when he got injured, but after his injury, when he was trying to go back to work, he couldn't do that job because it was like heavy
Hmm.
lifting and stuff.
Yeah, yeah,
So
yeah.
he put himself through university courses. He never actually completed anything, but he did go through a couple of university courses to get like an English credit and things like that because he was trying to better his life. So I believe that
Okay.
the WSIB probably went, you can't do the heavy lifting and things like that. You did show that you were able to, sustain university for a period of time. Okay, let's do an in between. Let's put you into a college program for 2 years to become a paralegal.
I laugh at that. I was actually told by my retraining person that the WSIB doesn't pay for university. I later found out that was a lie. You know, that, and th this is key. One thing I would say to all injured workers out there, when you start to go through the retraining process, the assessment process, and everything, if you even have the slightest, just the tiniest concern, write it down and put it in the file.
Yep.
That way, Richard or myself or another rep can look and go, wait a minute, he started to raise concern with you here. Because if you talk to people, it's as though it never happened. They will oftentimes be transferred, gone, or sadly, sometimes they'll just lie and say you never said it when you did. So if it's in writing and in the file, there's no question anymore. I also tell clients too is when you call the board or when you talk to the return to work person, record every call. You have every legal right to record a call that you're party to, right? And that way it covers you when you run into these suitability questions. Because what concerns me, two things with that is one is they never had any input from him as to what you want to do. This is his life. He has a right to choose that, a charter right. The second one is from the human rights, from the mental and physical side. They never considered his physical disabilities as well as mental. Going through that huge transition in age is huge, right? The paralegal profession is a very competitive, it's just like being a lawyer in many ways and sometimes harder. It is, I would say in all honesty, I wouldn't pick this profession for injured workers for two reasons. One is the the physical disability side of things, and then the mental injuries as a result of dealing with the board, the depression, the anxiety, and everything. Probably one of the greatest failures in society is not recognizing mental injuries. They look at you and say, "Well, you look fine to me," and yeah, maybe that's true, but mentally inside, they're broken and they can't function.
One
And
of
I
the
think that's a
interesting
huge issue.
one of the interesting things in this file is one of the psychiatrists said he could probably do paralegal from a psychological perspective, as long as he doesn't have to deal with the Workplace Safety and Insurance Board, because he's developed acute anxiety in dealing with them.
I'm
The
not the, yeah, yes, no, that's true. That's very true. Like, I've found that I can deal with other client files at times, and I do get very passionate. If you noticed with Pam there earlier about human rights, um, and when representing clients with disabilities, it's very difficult. And it's what's even more difficult is trying to explain that to like lawyers or judges.
second part of this case is Mr. Backman. What's Backman's first name?
Marcus.
Marcus Backman. So Backman has training in vocational rehabilitation. He's been a vocational assessor for 30 years, for the last 20, mostly working privately, doing opinions and assistance. There was a time when he actually worked for WSIB companies that were doing vocational training. He's been cited probably in about 15, 20 WSIAT decisions where they've used his reports and given him credit for his expertise and his opinions. So in this particular case, what Backman said was that the worker needs intensive assistance from a vocational rehabilitation specialist, so that they can work closely with the worker to slowly build up uh, his confidence and a resume that would assist him in getting a job. So, for instance, doing volunteer work for a while till he builds up a resume that would show somebody who needs a paralegal that this is a person who has skills and experience that would be of assistance. So Bachman said that without that, the 133 hours that he did, where he was mostly just filing papers and got no experience that was of any value, was simply not going to make him employable. The I think the ARO completely ignored Bachman's report, saying,
Actually,
"You
actually,
passed,
Richard,
you can do it."
now,
Yeah.
sorry, Richard, now paralegals, as of, I don't know, some time ago, paralegal students are now sort of like law students now, where when they're interning for me or you, they can actually represent clients in a limited capacity in limited situations. So, like, they could attend in criminal court, case management court, they can do that, as well as maybe some other tasks like that where they don't need me or you there. They can do it on their own. If I'm like, you know what I mean? There's conditions just like law students where, I have to be comfortable with them that they know the case and they know how to do it. So, I mean, that's another drain on the person. You know what I mean? For them to be expected to do that kind of work because 4 weeks it's a lot, but it's also not a lot. You know what I mean?
Yeah.
Because
It's
it's like a lawyer, you get all your real experience when you're actually working in the field.
yeah.
They
Oh,
had him 4 weeks attending criminal trials and assisting the lawyer or the other paralegal in preparing the case and getting it moving. You could say, well, look, he at least had 4 weeks. Maybe he could find a junior job assisting some other paralegal in criminal cases for money. but 4 weeks of just doing some filing work, you're not even fit to be a legal assistant, let alone a paralegal. Let
Yeah.
me just go with one further comment, which is about 20 years ago, the board would publish statistics on the percentage of injured workers who found a job after the retraining program. And my criticism of them at the time was it's all very nice you did this study a year or two after they completed, but how about looking at it 6 years later? Are they still employed? Like do a detailed study over time. And if they're, I haven't seen a study out of them in 15 years minimum, let alone a study of lengthy time. And I think the reason is that the overall philosophy of the WSIB is we gave you X, i.e., we gave you a year and a half of retraining, which included some coursework. Often it's English upgrading, math skills. We gave you a vocational rehabilitation counselor who showed you how to do resumes and apply for jobs. We gave you some assistance as you were applying, and you're done. It's sort of like we have a program, we give it to you, and we don't care if it's adequate or not. We don't care if you found a job or not. It's done. And that's why they don't watch statistics on this. They're not interested in the results. They're just interested in saying, we gave you something we feel is reasonable. Goodbye.
I
I,
can I
I
just sorry, I just want to
Go
point
ahead,
out
Pam.
two other things before we finish off on this. So, because we are going through the criteria. So I went through the first two. Third one is, can the person do the job? Can they be retrained? Do they have transferable skills to do the job? That's pretty standard. The final criteria, which kind of goes with what Richard's saying and what we've been talking about, is the compensation. So what it is the WSIB looks at your pre-accident earnings. They are trying to retrain you in as close to your pre-accident earnings as possible because at the end of retraining, whether the injured worker finds a job or not, your LOE benefits are adjusted or cut off. The WSIB pays you 85% of the net difference between your pre-accident earnings and the suitable occupation earnings. And I don't know how many times injured workers have called me and said, why did they cut off my benefits at the end of retraining? I have not found a job. They do not understand that they are going to have their benefits cut down or in many cases cut off. They also don't understand that if they are determined to be making minimum wage at the end of retraining, every time the government of Ontario increases minimum wage, the gap between your pre-accident wage and your minimum
Yeah.
wage becomes smaller. And therefore, until you're actually locked into your benefits until age 65, the WSIB can continue to reduce your benefits even if you don't have a job. This also includes, hey, your benefits haven't been locked in until age 65. You got retrained 5 years ago. We just did our annual review late, and we've determined that the occupation you got retrained in, those earnings are actually higher than they were when your retraining ended. We're cutting your benefits down. There are
Yeah.
so many people that don't understand this, and the WSIB needs to clearly outline this to people because they don't understand. This is their financial means to be able to pay their bills, and it's so frustrating that people don't know this.
The
I
final
think
word to Paul.
um I just wanted to add about what you were talking about is the retraining programs. Like back when I did it in the early 2000s, they called them labor market reentry programs. Same thing. I wonder if somebody at the WSIB has a full-time job just coming up with names because it feels like it. I mean, why do you change it? It's the same thing. But at any rate, what I was told by the board, the case manager, adjudicator, another name change, appeals officer, and even at the tribunal level is you only get one retraining program and that's it. If it doesn't work, well, that's your tough luck, right? Doesn't matter about the law, the codes, or anything else. This is a policy they've done for years. The other point I wanted to bring up was something that injured workers and RUP should be aware of is that in 2010, remember the infamous David Marshall, in Butterworth, the legal textbook for workers' comp, it actually referenced that the WSIB had a covert policy of forcing all workers back to work. In other words, they would refuse to declare any worker unemployable. And I've called them out on it a few times. It's not true. It pretty much is. How else did they get these billions in surpluses? And this is the impact we're seeing, where I was surprised to hear from some injured workers where they're not doing one retraining program. In some cases, they're doing 10 and 15 to get some form of some kind of work. And many of them are physically unable to work, like they're literally in a wheelchair and can't function most of the day. You know, this is a greater problem.
Well, let's leave it there.
Yeah.
Thank you everyone for attending, and hopefully we'll see you again next week.
Thank you, everyone. Take care.
Yeah. Bye now.